Good afternoon, everybody. Welcome to our next one here in a series of virtual town halls regarding matters concerning notaries public, put on here by the Office of the Secretary of State of Maryland. Glad everybody is able to join today. Should you have to jump off halfway through the call or something, any technical issues, no worries. This town hall is getting recorded, and that recording will be posted on the main notary page of the Office of the Secretary of State's website. Usually is up within a week or so of this town hall occurring. So should sometime later this week be able to find the recording for this town hall on our website. And so as you see at the bottom of the note on this first slide here, the content presentation provided is for informational purposes only. It is not intended to be legal advice. Again, the content presentation is provided for informational purposes only. It is not intended to be legal advice. If you have any questions, hopefully about this subject matter, we're going to talk about stamping device, otherwise known as a seal, your notary journal, and the fees you're allowed to charge. Hopefully you'll find that they're answered during the town hall presentation. If you have any questions that aren't answered, feel free to throw them in that chat box. One of our notary officers will be monitoring that and answering those questions as she may decide to hold some for the end, especially if there's a common theme amongst some questions that are asked. And to avoid any confusion, though, if you ask a question in that chat box, please don't answer it. Let our notary officers answer it. I always appreciate well-intentioned folks trying to answer it, but we've learned from reading some of those chat boxes and transcripts after the fact that some well-intentioned folks don't always throw the right answer in there. So leave it to our notary officers, not notary publics, but notary officers here are employees at the Secretary of State's office to answer those questions. And this town hall is being recorded, so that email notified you of that, and by participating you are consenting to the recording of this town hall. Before we get started, with me here today is our Deputy Secretary of State, Michael Laurie. So Michael, if you want to say a few words to welcome everybody.
Yes, welcome. Thanks, Mike. And he is our resident expert. We've got a great staff here to support your needs, and you have an important public trust. So steal a line from a famous politician from the 80s. So, trust but verify. So we want to make sure you guys are in line with not only the law, but what is expected of you from the public. But we do trust you. We hope that you'll learn all of the ins and outs, and feel free to ask questions, give us feedback. You can reach out to me directly, but I'm sure Mike will be able to answer your questions faster than I will. I'll probably check with him if I have a question. But we're here to serve you as you serve the public. We really appreciate your public service, and I know the Moore Miller administration is really grateful that you're raising your hand, stepping out to serve, and learning these important duties which you're obligated to understand and follow. But we really appreciate you stepping up, and please view us as a resource as you are engaging or continue to engage with this important function of government. So thank you.
Thanks, Michael. Appreciate the kind words. Yep, a very important office, one that does require and hold the public trust. So notary public and officer of the state of Maryland, when you're performing those duties, and always important to remember that when acting as a notary public, you're acting as an officer of the state, and therefore you're held to that high standard and public trust on what it is you are doing. Today, I mentioned earlier, we're going to talk about the notary stamping device, often more commonly referred to as the notary seal, the journal requirements, what many folks that have been a notary for a while may call the Fair Register of Official Acts, and then the different fees we're allowed to charge. And this trying to take some of this information used to be part of a different town hall. We're just going to take these sections out and emphasize them. These tend to be some of the most frequently asked questions that we receive from folks both on town halls and just in regular line of work, outside of notary application questions and how do I do it or checking my status. These tend to be some of the most frequently asked topics. And then we'll have additional town halls, as you probably saw from our invitation to join this one, throughout the course of the year on other topics. Next one up will be about notarial acts that you may perform and the notarial certificates that go with them. So today, stamping device, journal requirements, allowable fees. We're going to get started here, and as always, sources of legal authority. Notary public is actually referenced in the Maryland Constitution. Then much of what we're going to talk about today here is found in the Annotated Code of Maryland, Title 18, subtitles 1 and 2. And what's not covered there is going to be covered in the Code of Maryland Regulations, section 01, 02, 08, sections 01 through 17 are the full slate of notary regulations that notaries are required to follow in addition to that law. So first thing we're going to talk about is the notary's official stamp. And again, oftentimes folks refer to this as a notary seal. The law, when it changed significantly in 2020, started referring to your notary seal as a stamping device. So if you're ever reading the law and wondering, stamping device, it means your notary seal. It could be a stamp. It could be the embosser that makes the raised paper marks. One or the other, either one of them is an official stamping device. So the law also defines official stamp as a physical image affixed to or embossed on a tangible record, or an electronic image that's attached to or logically associated with an electronic record. So every time you're notarizing a document, a record, you're going to affix your notarial stamping device, your notary stamping device, to the document that you're notarizing, to the record that you're notarizing. The law uses the term record now rather than document. So thinking of record as a document, whether it's a paper document, i.e. tangible record, or electronic record, it's a record nonetheless. So you have to attach it or logically associate it with. Attach, what does that mean? If it's a stamp or an embosser, you stamp the page or you make the embosser mark. If it's electronic record, you're electronically affixing or logically associating, as the law says it, that electronic seal. And I mentioned earlier, it could be an ink, it can be an embosser, or it could be electronic if you're doing a notarization on an electronic record. The notary's official stamp must be able to be copied together with the record to which it is affixed or attached or logically associated. Right, stamps, easy to copy. The embosser, if you shade the paper right, you can copy that image as well from the embosser, so that it can be reproduced if it's done in a certain manner. And the notary stamping device is a public seal for the purpose of this particular section of the criminal law article. Why is that important? Well, you can't falsely or corruptly affix a public seal. If you're a notary, you affix your seal. Nobody else should be affixing your seal. You shouldn't let other people affix your seal. We're going to talk about that, but it's against the law to falsely or corruptly affix a public seal. A notary public stamping device is a public seal. The notary stamping device needs to contain 3 pieces of information. We're going to talk about a couple other things there that it may be on there that people often ask about. The 3 things you need to have: name of the notary public as it appears on the notary's commission. And if I'm John Smith and I'm commissioned as John Smith, my notary seal needs to say John Smith. If I'm John A. Smith, my notary seal should say John A. Smith. If I'm John Allen Smith, my notary seal should say John Allen Smith. However your name appears on your notary commission, that is how your name should appear on your notary stamping device, on your notary seal. So make sure it matches. Important point there is when you get commissioned, when you apply and get approved, or when you renew and get approved and you get sent an email telling you to go get sworn in as a notary public for your first or your next commission, one of the things in there that it asks you to do is verify the name as it appears is correct, because we want to make sure before you go to the courthouse to get sworn in, and then you go buy your notary public seal and you start notarizing, that the right name is appearing on that commission. So you always want to double check that before you go get sworn in. Every time you get a new commission, you want to make sure your name on your commission appears correctly in the way it is supposed to appear. Second thing that's always required on a notary seal are the words notary public. And the last thing that always needs to appear on a notary seal is the county, or if commissioned in Baltimore City, in which the notary resides or was qualified. So in other words, wherever you get sworn in for your notary commission, that's the jurisdiction that should appear on your notary seal. Let's say I live in Anne Arundel County. I'm going to be sworn in at the Anne Arundel County Clerk of the Circuit Court. Therefore, my name would say Michael Schlein, Notary Public, Anne Arundel County. So name as commissioned, the words Notary Public, and the county in which you're commissioned, unless, of course, you're commissioned in Baltimore City, in which case you would say City of Baltimore or Baltimore City instead of Baltimore County. And thinking of that, we see a lot of folks will put Baltimore City County on their seal, or Baltimore County City. That's not a real place. Either City of Baltimore, County of Baltimore, Baltimore City, Baltimore County, not both. You get sworn in at one or the other. You don't get sworn in at both. So make sure your seal does not say Baltimore County City or Baltimore City County. They are different jurisdictions, and they are not the same jurisdiction. Effective October 1st, 2020, the law also talks about the notary having their expiration date on their notary seal. And that is true unless, of course, the notary's expiration date appears in a notarial certificate. Those of you that are very familiar with the requirements of notarial certificates and have ever looked at the sample certificates in the law or in the handbook will see there's often a spot on the certificate for the notary to write their expiration date. So if you're able to write your expiration date as part of the notarial certificate, you don't need to have the expiration date on your seal. So that's why I don't have it listed as a fourth item above. It is a maybe you need it on your seal, maybe you don't. If it's a part of the notarial certificate, you don't have to have it on your seal. Every notarial act now requires a notarial certificate. So there should be a place for it to write in which case, if it is, you don't have to have it on your seal. A lot of folks will say, but Mike, what if I put State of Maryland on my seal? Great, as long as you have these other three things. Name as it appears on your commission, the words Notary Public, and the jurisdiction in which you are commissioned should all be on your seal. If you want to throw something extra like State of Maryland on there, that's fine. You don't have to have State of Maryland. You have to have these three things. You can add State of Maryland if you want, but you don't have to. So you can have that on there, but these are the things you must have on there. So if you have State of Maryland on your seal, as long as you have these other three things, you don't have to worry about getting a new seal. You can keep it. You don't have to have it, but you can. So the most important thing about seals, other than always remembering to affix them when you notarize something, is that it's your property and your responsibility. That notary seal is yours. It has your name on it. It's a public seal. We talked about public seals and falsely and corruptly affixing briefly there. It's your seal. It's your responsibility. You need to keep possession of it. You need to store it securely and safely. Shouldn't let anybody else use it, right? Your name's on it, not anyone else's. So what happens if you let somebody else use your notary seal? Whose name is it? Who are they going to come back to if something goes wrong? You're the individual that's commissioned as a notary public, as the officer of the state, not anyone else. So you want to make sure you securely keep that stamping device, that notary seal. You want to make sure it stays in your possession. And it's your property. Even if someone else bought it for you, it's still yours. It has your name on it. This sometimes we understand it can be a point of contention, but even if you leave your employer, you need to make sure that seal leaves with you. And that is tremendously important. I've heard many horror stories about notaries that did not take their seal with them when they left, and guess whose notary seal still ended up on stuff at that old place of employment. Take it with you. It is yours. Take it with you. Just like the journal, and we'll talk about that too. It is yours. It is your property. If you keep it at your place of employment because you usually notarize for work, keep it safe and secure. Keep it in a locked drawer. Don't leave it out on your desk. Don't leave it easily accessible. Don't tell everybody where it's at, where they can easily get it. We all like to know, love, and trust the people we live with and work with. But again, we got some stories. We have stories about folks that did just that, left it on their desk, went on vacation, left it on their desk, and little did they know that notary seal did a lot of work while they weren't around because someone had access to it, and that person may have been using it for some malicious purpose. And again, guess who gets that phone call when that happens? Who do they think did it? They think you did it because your name is on that seal. So keep it securely. Your responsibility. It's your responsibility for the security of that stamping device, and never allow another individual to use it. It doesn't matter if you're there or not. Never allow someone else to use your notary stamping device. It is yours, even if you know what they're doing it for. They're not the notary you are. You cannot allow other people to use it, and you don't want to accidentally allow other people to use it either. So I've kind of gone over the scary sounding part, right? Very important. Seems petty, seems simple. Who would ever do that? Trust me, it happens. It happens, it happens, it happens. So make sure you keep it in your possession. If you lose it, you let us know. Tell us if it's lost or stolen. Tell us if it's missing. Let us know so we know, so we can note your file, your profile, so to speak, so that we know that your seal was lost or stolen. And that way there's a record of that being reported. Should anything bad ever happen or come of it, right? You never know where that seal is going to go. Maybe it's just lost, or maybe it was stolen or misused. Let us know if you discover that to be the case. And, if you've resigned your commission, or your commission expired, or worse yet, was revoked for some wrongdoing, regardless, you must disable that stamping device by destroying, defacing, damaging, erasing, or securing it against use in a manner that renders it unusable. So make it unusable, destroy it, disassemble it. If it's a stamp, you can pull that ink stamp pad right off pretty quickly, right? And those embossers might be a little harder to destroy, but if you're having a bad day and you're no longer a notary and you don't need that notary seal anymore, take it out on that seal, right? But make it unusable. If you're no longer a notary, you don't want that seal floating around out there. Render it unusable so that no one else can use it. Long ago, I don't know, never say the names of who. I remember being told a story specific. I just threw it in the trash. Well, that notary seal ended up on things like 2 years later. So even though they threw it in the trash, they thought, who would use a notary seal out of the trash? Somebody did. Crazy but true. It happens. So other than talking about security, you mentioned earlier, stamping device must be capable of being copied with the record to which it's attached or affixed or logically associated. And, again, referencing that both the stamp and the embosser are regularly used in Maryland and just fine. One makes the ink stamp, right? One makes the raised paper marks. Either one will do. I'm going to go back to here before I get into notary record keeping again. Just want to emphasize that notary seal has your name on it. It is yours. Don't let anybody else use it. Don't let anybody else take it. Take it with you. If you go somewhere, if you change employers, take it with you. Take it with you. Take it with you. Don't leave it behind. Many, many, many scary stories of things like that happening. Even 5-10 years later, after somebody stopped working somewhere, a notary seal, if it was left there, may still end up being used. So take good care of that thing. It's yours, and let us know if it's ever lost, stolen, or anything else that requires or needs some level of reporting to us. So notary record keeping. One of our other big questions we get are what's required in record keeping. How long do I have to keep my record? How long do I need to keep my journal? So we're going to talk about all that here. And, first things first, the journal is required by law. It is required by law. You as a notary public need to keep a journal. Used to be referred to as a fair register of official acts. Now it's called a journal in the law. Every notarial act you perform, you must put it in your journal. There are no ifs, there are no ands, there are no buts. Every notarial act goes in that journal, whether it's somebody you've never met before and you had to identify, or somebody you see every day and notarize for every day. Every notarial act must be chronicled in your journal. It is a requirement of the law. Folks always, but I know the person, I didn't. Yeah, you know him, you still got to put it in the journal. I work with them, I see them every day, still got to put it in the journal. Still got to put it in the journal. But I keep copies of different things that I still got to put in the journal. Journal is a requirement. The law requires it. It does not make exceptions for any of those reasons to not have a journal. Got to have that journal. If a notary notarizes for the same people all the time, doesn't matter, right? We just talked about I do it every day for that person. Still got to keep a journal of your notarial acts. Entries in those journals should be made contemporaneously with the performance of each notarial act. So what does that mean? At the same time or occurrence, contemporaneously. We're here, I've identified you, I've watched you sign, I've completed the certificate, I've affixed my seal, I've made the entry in my journal. That's all happening at the same time and occurrence as the notarial act itself. Can't go make that journal entry a week later. It all happens in real time. Make it a part of your practice. If anybody has read our handbooks and you look at the different type of notarial acts we perform, we don't list the journal last. We list it somewhere there in the middle to the beginning to the middle. Right? We want you to make that entry in that journal. It's not the last thing you do. It should just be part of the notarial act process. Every time you notarize, a journal entry is made. Make it a part of your routine process, not just because it's there for your own good, and not just because the law tells you. It is there. You got to do it because the law says so. But it will also help you should there ever be a need or a reason to go back and look at that, should anything get called into question. A good journal explaining who appeared before you and how you identified them, and we'll get to the requirements of every journal entry here in a minute. That good journal is going to save you because you can show that you satisfactorily identified somebody, when you identified them, how you identified them. If you have all your entries in your journal and you do them contemporaneously with the performance of the act, those journal entries are always in order, and it leaves no question. You have a consistent record-keeping practice, and it lends far more credibility to you should there ever be a question. And the notary shall retain the journal for 10 years after the performance of the last notarial act that's chronicled in the journal. So you can't just start ripping out pages once they hit 10 years. 10 years after the performance of the last notarial act chronicled in that journal. So that last journal entry, you need to keep that journal for at least 10 years after that last journal entry that is recorded in that journal. 10 years, not whenever, not, oh, I changed jobs, I got a new journal. Is yours, just like the seal. It is your journal. It is your record of what you've done acting as an officer of the state. It should also go with you whenever you move or leave or what have you, right? It's your journal. Because should there ever be a question, you're going to be the one asked, not your previous employer or coworker or whoever. Your notarial act has your name on it. You're going to be the one that's asked about it later. It's your journal. You need to keep it. You want to keep it. It's in your best interest to keep it. And for several reasons, not just because the law says you have to. If a notary public's journal is lost or stolen, promptly notify us. Tell us that happened. Tell us if you know when about that happened. Or if you don't know when exactly it happened, but you just realized it, tell us that. That way we know. Right? That way we know. That way there's an expectation of when you'll have a journal and when you may not have a journal, should there ever be a question that we need to ask you about. Should anybody else ask you a question and you don't have it, you've reported it to us, and we know that you don't have it. So these are kind of the basics, the outline of the notary journal, how long you need to have it, 10 years from the last entry in that journal. And everybody said, Mike, I notarize a lot. I got 3 journals. You know, they're yay thick, right? Throw them in a file cabinet, put them in your desk at home, put them in your desk at wherever you keep your documents for safekeeping, wherever you keep your notary seal for safekeeping, put it there, right? Put it there. It doesn't take up a ton of space, and but it's securely kept, and you can access it should you ever need to. Always take care of that thing. It is your backbone. It has your back should there ever be a question. Like I said, if you don't keep it for any reason other than that, great. It's required by the law. Yep. You need to have it. Yep. But it has your back should there ever be a question. Require documentation in a journal entry. So every time you make an entry in your journal, you need to record certain things on that line in your journal. First of which is the date and time the notarial act was performed. Every time. Every time. The description of the record, if any, and the type of notarial act. So if you notarize, whatever, fill in any name of any document, and then what type of notarial act you performed. Did you do an oath? Did you do an affirmation? Did you do an acknowledgement? Was it a certified copy of an electronic record into tangible? Was it attesting or witnessing a signature? So the type of record and the type of notarial act. They're different. The record is, what's the title of the document, so to speak, right? A description of the record. The type of notarial act is, what did you do as a notary? Did you witness a signature? Did you have somebody attest, or did they take an oath, or did they take an acknowledgement? That's the type of notarial act. So full name and address of each individual for whom the notarial act is performed. Full name and address. If the identity of the individual is based on personal knowledge, a statement to that effect. So how did you identify them? I know them. We're not going to get too deep into personal knowledge and what that is exactly, but you know them. You don't just know them in passing or know them because you see them every now and then at your business. You know them. You know about them. You know who they are and stuff about them. Personal knowledge. You make note of the fact that you use personal knowledge. If you have to identify the signer using an identification credential that's presented, a brief description of the method of identification and the ID credential presented, if any, including the date of issuance and expiration of any ID and the ID number associated with the identification credential. Most folks in Maryland are going to show you a Maryland driver's license or a non-driver ID card. There's a number on there, noted in your journal. Note the issue and expiration date of the ID you looked at. Right? Every time you notarize, every journal entry should explain how you identify them. Did you use personal knowledge, or did you identify them using some identification credential like a driver's license? And if you use the driver's license, you're going to note these certain things about that driver's license or non-driver ID card in your journal. The fee you charged, if any, will be recorded in that journal. We're going to talk about fees after we talk about the journal. Do you charge a notary fee? You need to explain the notary fee. What did you charge? In a later slide, we're going to talk about traveling to notarize and what you can charge. If you charge for the notarization and travel and whatever else you're allowed to charge for, maybe you don't just list the total in there that you charge, but maybe you break down how you came to that total. Should there ever be a question? They overcharged me. They're charging too much money. Well, you know, I charged you this per notarial act. I charged you this for travel and this for mileage, and that's why I have this fee. Right? That journal entry is going to have your back on that if you're charging them correctly. So if there was no fee, indicate there's no fee. If you're a notary that doesn't charge for notarial act, indicate that. $0 or no charge or NA, something to indicate that you're not charging the fee per notarial act. Not everybody charges. And then you can indicate whether an individual is making a statement or executing a signature, which is the subject of a notarial act that appeared in the notary's physical presence or remotely by means of communication technology. What does that mean? And everyday people talk. Did you do an in-person notarization or did you do a remote notarization? So indicating that it was in-person or remote. And if you only do in-person notarizations, easy to answer, right? If you do both, depending on the types of remote notarial acts, you may have a different electronic journal than you do tangible record. We're going to talk about that here. So journals may be created on a tangible medium or electronically. Tangible on paper in book form. The notary shall maintain only one journal to chronicle all notarial acts performed regarding tangible records. So your regular run-of-the-mill notarial act, you watch somebody sign a sheet of paper, you notarize their signature, you complete the certificate for oath, acknowledgement, affirmation, official witness, what have you. But it's a document, hard document in front of you, a tangible record. One journal for those notarizations. One journal. That journal for tangible notarial acts must be a permanent bound register with number of pages. So it needs to be a bound journal book. It has to have numbered pages in that journal. So if you're notarizing the traditional way of paper documents, paper records, when you keep your notary journal, you make your entry, it should be in a bound book with numbered pages. So that's for tangible notarial acts, or notarial acts on tangible records. Now we're going to get into journals for notarial acts on electronic records. You could have one or more journals for notarial acts performed regarding electronic records. Those electronic journals for those electronic records must be in a permanent, tamper-evident electronic format that complies with the laws and regulations adopted by the Secretary of State. You know, well, how do I know? Well, if you're doing remote notarial acts, especially, on electronic records, you have a remote online notary vendor provider. You have a RON vendor or more, one or more, for which you're using their technology to perform a notarial act. That technology should include journal capability. Maybe use more than one RON vendor. Well, you might have a journal for notarial acts on this RON vendor and one for electronic record notarial acts on this other RON vendor, and that's fine. So if it's a tangible record notarial act, one book, one journal to chronicle those. You don't get to start a second tangible notarial act journal until you've filled up your first book. You fill up your book, you start a new one, you keep your one you filled up for 10 years, right? If you're doing electronic notarizations, notarizations on electronic records, you could have more than one journal to chronicle those electronic notarizations. So a few other things here about the journal. The notary public engages with the third-party repository. The contract shall enable the notary to comply with any retention requirements or provide that the information will be transferred to the notary public if the contract is terminated. So referencing our RON vendors again, there should be some mechanism there when you use them and you're subscribed to them or pay to use their service or however that particular platform works, that allows you to access those records from your journal on that platform should you no longer use that platform. Or however that process plays out when you use that platform. So record keeping, a third-party storage repository could keep your records. That's fine as long as there's a contract. We don't have a list of approved repositories, But if you have a contract that takes care of the record keeping requirements and allows you to do these things, that's deemed sufficient. If you resign or you're revoked or suspended and whatnot, still got to keep that journal. Still got to keep that journal, as described on these previous slides. 10 years from the date of entry, last date of entry in that journal. And inform the Secretary of State where the journal is located if need be. And so it's a requirement to keep the journal. Even after your commission expires, you're still going to keep that journal. Still need to keep that journal. And so 10 years from the date of last entry in that journal, if somebody were to pass away, the notary's personal representative or guardian or other person in possession of the journal could transmit it to a repository approved by SOS. We don't actually have a repository. It's approved by SOS. That's a cutout from the law. Otherwise, they'd be responsible for keeping that journal themselves. So talked about stamps, talked about journals. At the end of the day, have a good stamp, take care of that stamp, be in possession of that stamp. Keep a good journal, take care of that journal, be in possession of that journal. Those are yours. It is your property. Don't let anybody else use it or have it. You don't know how it's going to end up. It's yours. Charges and fees. Charges and fees. So we're going to go over different things that a notary can charge for. And I'm going to get ahead of any questions. Every time without fail, we always get different questions about charging for notarial acts or what else can I charge for? As a notary public, you can only charge for these things. These things, and we're going to go through each of these things on the screen one by one. Folks will say, well, you know, I'm a mobile notary. I go places to notarize. Here are the fees you can charge to go places to notarize. No other fees. Can't set your own fees. There's no convenience fee. There's not an after-hours fee. But Mike, they call me at 2 in the morning. This is the only thing you can do right here. If you travel at that hour to notarize, it's the same thing as if you traveled at 2 in the afternoon to notarize. But I had to go out on my way to note. Okay, this is still what you can charge. These are the fees that you can charge to notarize in the state of Maryland. No matter what you want to call yourself, no matter what time of the day it is, no matter what other fee or charge you want to tack on, this is what you're allowed to charge when acting as a notary public. Nothing else. No convenience fees, no after hours or nighttime fees, overnight fees, after hour fees, weekend fees, no other fees. No other fees. You can charge up to $8 for the performance of a notarial act. That's the fee for each signature that you're notarizing. $8 per notarial act, up to. Don't have to charge $8. You could charge less. You could charge $0. Anywhere from $0 to $8. $8 is the maximum fee you can charge. And receive. And it's the phrase in the law is demand and receive up to $8. So what does that mean? One of the other questions folks like to ask, well, what if they want to tip me? Nope. Not according to the law. The notary may demand and receive up to $8 for the performance of an original notarial act. Can't take more than $8 per notarial act, no matter what you want to call it. Additional copies of the same document. Notary may receive $4 for each signature notarized. So you have two of the exact same things that you're notarizing, $8 for the original, $4 each signature for the second. You may not demand and receive more than $2 for a photocopy made of a notarial act. Somebody wants a copy of something you notarized, you make a copy for them, you could charge them up to $2 for that. If you have to travel, you can charge for mileage at the IRS mileage rate for business travel. So the Internal Revenue Service every year sets the business travel mileage rate. We try to keep up with that and post it on our website. Right now it's 67 cents a mile effective January 1st. If that changes in the year, we'll try to keep up with that. The best thing to do if you want to get it, make sure you're accurate up to the minute, just Google search IRS mileage rate for business travel. You'll get a quick hit on that. It'll tell you exactly what it is. But the IRS posts that. They put out a bulletin usually every year, or if it changes during the year, they put out a bulletin in the middle of the year to help you with that. So make sure you're looking that up. Notary Public may also demand and receive a fee not to exceed $5 for travel. So if you have to travel, and we're going to go about how to break this down on the next slide, you can charge them a $5 flat rate plus the mileage. That's in addition to the mileage if you have to travel. And if you're doing a remote notarial act, you cannot charge more than $30 for the performance of the remote notarial act. So $8 for traditional notarial act, $30 for remote notarial acts. No more. Less if you want, but no more. So those are the maximum fees that you can demand and receive. Can't receive more than the maximum either. Right? Can't receive more than the maximum either. So, again, $8 per notarial act. You got to travel somewhere, that's $5 plus your mileage. If it's a remote notarial act, you're not traveling anywhere because you're doing it remotely, $30 per remote notarial act. And that should help you cover those technological fees that you have using certain RON vendor platforms that you're going to pay to use to perform remote notarial acts. Right. So $30 per. And that's the maximum as set in the regulations. And that just went up a little earlier this year in January. Used to be $6 per notarial act and $25 for remotes. Now it's $8 and $30. So a little example, we got a little use case scenario here for notarizations. So let's say a notary public is asked to travel to perform a notarial act on a tangible record. The notary must travel 30 miles for the performance of their duties. When the notary arrives, they must notarize the signatures of 2 individuals. They may charge the following. So for the performance of the notarial acts, $16, right? 2 individuals signed it times $8 per notarial act. Plus, they're allowed to charge $5 because they had to travel. Plus, they're allowed to charge for those 30 miles at that mileage rate. So obviously, the mileage rate, if it changes, it might go up or it might go down. Then the mileage fee would change because it's dependent upon how many miles you traveled at how many cents per mile. But today, in this example, 30 miles at 67 cents a mile would be $20.10 for mileage. So the maximum amount that a notary public could demand and receive in this scenario is $41.10. $8 per notarial act, plus $5 because you had to travel somewhere to get there to do it, plus the mileage that required you to travel there for this notarial act. $41.10 in this scenario. I'm going to let this slide stay up for a minute just to kind of help it sink in. The number one question, well, I don't know if it's the number one question, but one of the number one questions we get asked during town halls are about fees. And if you kind of figured out by how I led on that prior screen, that prior slide, I was talking about the fees you're allowed to charge. I always appreciate the creativity that folks have in trying to figure out a new way to make that extra buck or two. But when you're acting as a notary public, you're acting as an officer of the state, you're allowed to charge for certain things when acting as a notary public. People will ask, about different things, but that's kind of what it is. One of the aspects that folks will ask about is, is it round trip mileage? Well, if you had to travel to that place, you had to travel back, right? So total mileage that you needed to take to do that notarial act. Total mileage, there and back. I traveled 5 miles to you, I traveled 5 miles home. That's 10 total miles. So notarizing in this scenario, here's the breakdown. If it was 4 individuals, it'd be $32, right? Because I notarized 4 people times $8. If it was just one person, it's $8 plus $5 plus mileage. So this is the this is the breakdown of this. And if it's a different amount of people, you just got to change the numbers in the math. $8 per signature. $8 per notarial act, right? Every signature you're notarizing, that's one notarial act. So if it's 10 people, it's 8 times 10, right? 80. 5 people, 8 times 5, 40. One person, 1 times 8, 8. So you do the math on that to get you home plus the mileage. And people often will say, well, it's a $5 travel fee. Yeah, $5 because you had to go somewhere plus the mileage. The mileage isn't capped at $5. It's $5 because you had to travel plus the mileage. So I just want to drive those points home. We get asked that question a lot. And I bet I'm not paying any attention to the chat box at the moment, but I bet you a lot of those questions in there. So hopefully that answered all those questions you have. And people will talk about other types of things. Think about being a notary public as an officer of the state. When you're notarizing, your job is to be the notary. It's independent of all those other jobs you may have at your employment that you may charge for service on. The notarial act, the notarial service, it's its own thing. When you're a notary, you're a notary. You're not anything else. You're the notary. So whatever you charge for in your other profession has nothing to do with the notarial act. When you're charging as a notary to notarize things under the powers you have as a notary public, these are the fees you can charge. It's important to make that distinction. These are the fees you can charge in your role as a notary public. I'm going to bounce back to them one more time here so everybody can kind of take a peek. And again, this is going to be recorded. This is not just going to be, this is being recorded. So this recording is going to pop up online here in the next few days. So if you missed it, you can always, when that recording's posted, just forward this presentation to the screen if you want to get a look at it. It's in the handbook. If you bought the handbook and have the handbook, it's in there. And if you go to the notary page and you go to our frequently asked questions, one of them is about the fees you can charge. It's found there as well. So it's in a few different places. But these are the fees you can charge as a notary public. So just some helpful information for you to have. Folks, oftentimes, I was reading online, and the first question I always ask somebody is, what website? Because anybody can say anything online. And I know deep down, we all know that, but you just kind of get hung up in the moment. You start reading something, and you may not be paying any attention to the fact that that person's a notary from a whole nother state, or better yet, a whole nother country. Well, every state's a little different in what they allow you to do and what you can charge and what your powers are. So if you're looking for information about Maryland Notaries Public, best place to go is our website, sos.maryland.gov. That first link is the main notary page. Right, there's an FAQ link you can get to from the main notary page. If you're looking for new application information, how do I become a notary? That link right there gives you all the steps. Renewals, same thing, but for renewals. Here are the steps. The last link you see there is a link to our authorized course of study and exam provider page. If you're a new and renewing notary, you have to take a class now to renew. And if you're a new applicant, you have to take a class and pass a test to be able to apply. And those classes are there. They're there for a reason. They're there with the intention of educating, and they all cover the basics of being a notary in Maryland. Pay attention to those classes because they're going to give you all that you need to know about being a notary. But when I talk about reputable sources, authorized course of study and exam providers, they're authorized by us for a reason. They've met the requirements and they're teaching you the stuff. That's a good resource. But other than them, you should go to our website, read the information there. If you're not sure, ask us. We'll have our contact information up in a second. Ask us, shoot us an email, make a phone call, ask us the question you have. We want you to succeed. We want you to thrive. We want you to do it right, do it well. It's always better to ask us and get it right than guess and get it wrong and hear from us later by maybe, maybe you'll never hear from us later. But better to ask and get it right than guess and be wrong and hear from us later. It's always better the first way, right? And so here's a few good pages to start your notary search off at. Folks are always, I saw this in a notary chat room. Ugh, I'm not sure, right? Who's running that chat room? It's only as good as the person that's administering that. And they may or may not be right, and they may or may not know. They're filled with ways to tell you how to make a quick buck. But maybe the full context of what it takes to make that buck extra from being a notary, that extra context may not be there or may not be explained well. So be checking the information and, start on our page, start on the notary landing page, start with your education and testing providers. If they taught you the information, not a bad place to go to ask a question if you know them and you're comfortable with them as well. So we're going to have some upcoming town halls. These are the dates right now. Pencil them in. Usually our town hall invitation comes about a week in advance from the town hall. So about a week before June 3rd is when we'll send out the link to the next town hall. And, barring something unforeseen, these should be the dates. If they change, of course, we would say that, and, we'll let you know in the emails that we use to announce them that the date may have changed, or if the times change. So we've been doing these at 2 o'clock, seeing if the afternoon works better. We've done a lot at 10 a.m. We're gonna try the afternoon here and see how that goes for everybody. But the time will also be in the invitation, so it's possible that some of these may be morning town halls. The November 4th one in particular probably will be, but it'll say in the invitation what time it starts at and what time it's running through till. And speaking of which, we're coming up on that time, so I'm going to be mindful of that. And overshot my slide there. And so before we break and do some questions here, we're going to go and cover, just kind of go over the beginning part again there. Again, this is content presentation is for informational purposes only. It is not intended to be legal advice. Not intended to be legal advice. It is for informational purposes. This town hall recording is going to be posted on our website, and it's going to be posted there within a few business days, but certainly within a week or so of the town hall. So take a look out if you missed any information there, and you can always watch it again later. You can always ask us if you have any questions. One thing I noticed is that there was supposed to be a contact information slide that I seem to have missed plugging in there. So we'll be sure to throw the contact information in the chat feature for the notary division, and that's the dlnotary_sos at maryland.gov, DL notary like division list notary_sos at maryland.gov. Phone number is 410-974-5520. It's the main notary line. DL notary_sos at maryland.gov, 410-974-5520. Hope this information was useful, and for those that want to stay on and ask some other questions, feel free to do so. Those that don't, take care of yourself, and thanks for joining us.